Well, as was said, this is our environmental justice track of our second annual Mid-Atlantic Summit at Region 3. I'm pleased to introduce the moderator of today's session, my colleague Daniel Isales. He's been a staff attorney for the U.S. Environmental Protection Agency, Region 3, since 1991. During that time, Dan has worked on Superfund, Oil Pollution Act, and multimedia regulatory enforcement actions, as well as matters involving environmental justice and Title VI of the Civil Rights Act of 1964. Most recently, Dan has been providing counseling services to various media programs under the Clean Air Act, the Resource Conservation and Recovery Act, the National Historic Preservation Act, and the Federal Insecticide, Fungicide, and Rodenticide Act. Dan is a graduate of Georgetown University, go Hoyas, and the University of Pennsylvania School of Law, go Fighting Quakers. Let me turn it over to Dan.
Good morning. Once again, I'm Daniel Isales, and thank you very much for joining us this morning. As Anhthu and I are both attorneys, we of course have to start with a disclaimer, the disclaimer being that the views that we express this morning are solely our own and do not necessarily represent those of EPA. So we're going to go through some basic background on civil rights laws and authorities with the idea that we will jointly continue to the journey to fully integrate civil rights obligations and environmental protection. I apologize in advance, as some of this information may be familiar to a number of you, but we want to make sure that we create a baseline of information so that we can all engage in this conversation. Now, the goals of this morning are fairly simple. I will cover some of the basics of the law, while my colleague Anhthu Hoang will discuss procedural requirements and best practices. Next slide, please. All right, let's start with, and if we could advance the next slide. Perfect. Let's start with some of the basics. And at the outset, what I'd like to do is compare and contrast some elements of Title VI and more generally environmental justice. Keep in mind that when we're talking about Title VI, you're talking about a federal law, the purpose of which is to ensure that funds are not being used in a discriminatory manner, and the responsibilities fall upon any recipient of those federal funds. For those of you who had a chance to hear all of the state secretaries just speak a second ago, you heard them talk about all of the big influx of federal funds coming in right now. Now, the type of discrimination that's prohibited is that based on race, color, or national origin, and enforcement of these rights are through administrative and judicial means. By contrast, when we speak of environmental justice, the movement is obviously based in the community, starts in the community. The federal basis of our authority comes from executive orders, which are not laws. So remember that executive orders do not have the force of law, and they do not create any rights enforceable in court. What they provide is direction to federal agencies, such as EPA, on how to manage their operations. When we speak about environmental justice, we frequently also include low income as a consideration, which is unlike Title VI. Next slide, please. So let's start talking about EPA's commitment to ensure that civil rights obligations are met. Next slide, please. In a communication last summer, our EPA administrator points out the need to strengthen enforcement of federal civil rights laws, which, as he points out, creates separate and independent obligations in addition to having to make sure that we commit to properly commit and enforce environmental laws. This is going to be a theme, and we're going to touch upon this a couple of times throughout our talk this morning. So next slide, please. Now, from the outset, I've been referring to Title VI of the Civil Rights Act of 1964. What am I referring to? Well, we begin with Section 601 of the Act, which states that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Now, we got to be clear that this isn't the only civil rights laws that EPA oversees. And next slide, please. In addition to Title VI, EPA also enforces Section 504 of the Rehabilitation Act, which prohibits discrimination on the basis of disability, the Age Discrimination Act of 1975, which prohibits discrimination on the basis of age, and Title IX of the Education Amendments of 1972 and Section 13 of the Federal Water Pollution Control Act, both of which prohibit discrimination on the basis of sex. And you can find EPA's non-discrimination regulations at 40 CFR, CFR being Code of Federal Regulations, 40 CFR parts 5 and 7. And next slide, please. With respect to the EPA regulations, and this slide shows a portion of it, taken from section 7.35 of part 7. With respect to EPA's regulations, this slide reflects the provisions from the EPA regulations, which are very similar to the regulations of other federal agencies. The one that I would highlight, which is the last bullet, is the one that talks about citing of facilities as being a basis of discrimination. This might be one that might be a little different from ones that you would see from other agencies. Next slide, please. I've alluded to this previously just a second ago when quoting the administrator's communication from last summer, but I really would like to emphasize this point again, that compliance with environmental laws by themselves does not guarantee compliance with civil rights obligations. Civil rights compliance is not only mandatory, but also a critical tool for achieving environmental justice when a permitting action is likely to have an adverse and disproportionate impact, particularly on the basis of race, color, and national origin. So enforcement of civil rights laws and the full use of authority and discretion under environmental laws are complementary. Used together, they help ensure the non-discrimination protection, the non-discriminatory discriminatory protection of human health and the environment. Next slide, please. So let's start doing a slightly deeper dive into the provisions of Title VI. So we previously read the language of Section 601 of Title VI, but let's focus on the highlighted terms. So let's move on to the next slide. First, note that it says no person. So to be clear, citizenship has no bearing in the protection that Title VI offers. Next slide, please. Now, the basis of discrimination under Title VI is race, color, or national origin. When talking about these, it includes any perceived race, color, or national origin, and an individual's accent, ancestry, birthplace, culture, immigration status, or language. In 1974, the Supreme Court in Lau versus Nichols found that providing language service is part of Title VI obligations not to discriminate based on national origin. EPA interprets its Title VI regulations to require all recipients to take reasonable steps to provide meaningful access to persons with limited English proficiency. That is, individuals who do not speak English as their primary language and have limited ability to read, write, speak, or understand English. Next slide, please. What I'd like to point out with respect to recipient status is that the obligations accompany the funding. So if there's one takeaway that you take away from this morning is I would just say follow the money. So that is, the Title VI obligations apply not only to the direct recipients of federal financial assistance, but if that assistance is passed on to another entity to manage the funds, then the Title VI obligations are imposed upon that subrecipient as well. So it goes along with the money that's received. Next slide, please. Now, I keep on referring to federal financial assistance, and obviously the go-to, the one that we typically think about is money, grants or loans that are given as part of the federal budget. But that's not the sole basis, and that's why I put in some of the examples that comes directly from our regulations. So these would include things such as donation of federal property or the detail of federal personnel. Next slide, please. Now, program or activity. With respect to program or activity, and when you hear the phrase all of the operations of any program or activity, I'm sorry, when you hear the phrase all of the operations of, and then also here, we might also hear the phrase of any program or activity, it means just that. It includes programs that EPA doesn't fund or oversee directly. For example, if an entity receives funding under the Clean Water Act, that entity must ensure non-discrimination throughout all of its programs or activities. That is, not just the water program that receives the funding, but also the air program, the solid and hazardous waste programs, and so on. Next slide, please. Now, there are a number of ways, a number of mechanisms to enforce Title VI. The majority of those presented on this slide are administrative, with the exception on when we have to refer a matter to our colleagues in the Department of Justice and seek judicial enforcement. Anthony will discuss each of these in more detail, but I will note, I do want to note that the Office of External Civil Rights Compliance has prepared the OECRC Case Resolution Manual, which is available at the EPA website and contains a lot of very useful information regarding the administrative process. And let's go on to the next slide. So, as I said, follow the money. And what I mean is the obligations start as soon as you start applying for that funding. And one of the things that makes it clear, in addition to the Form 4700-4, which Anthony will talk about in a second, is it's reinforced when you get your grant package and you see the standard terms and conditions. And that is very clearly laid out. And in the standard terms and conditions, it incorporates by reference the signed assurance provided by a recipient's authorized representative on the Form 4700-4 that talks about the measures that they've taken to date to make sure that they comply with civil rights obligations. So I'm going to turn it over to Anhthu, who's going to discuss measures that EPA uses to achieve compliance, and time permitting a discussion of best practices. So I'd like to introduce my friend and colleague, Anhthu Hoang. Anhthu is the acting director of the Office of External Civil Rights Compliance and is deputy director as well. During her time in EPA, she has worked as a policy staff in Region 2's EJ program and as an attorney in Region 2's Office of Regional Counsel. Prior to joining EPA, Anhthu worked in advocacy, advancing policies aimed at achieving environmental and climate justice, as well as human health protection in the San Francisco Bay Area and New York City. And in a previous life, she was also a university lecturer in biology and a researcher in ecology and evolution. So, Anhthu, over to you.
Thank you, Dan. Good morning, everyone. So I'm going to talk about what we call our pre-award review, which is what Dan had indicated, our 4700-4 form, which is an OMB form that all recipients of EPA financial assistance must sign and submit to EPA in order to receive their grant allotments. So one of the first things that we check are the things that Dan had outlined, whether the Form 4700-4 includes a disclosure that the entity has a notice of non-discrimination, which is in accordance with our regulations under 40 CFR 7.95A and 5.140, collect demographic data, have a limited English proficiency policy and procedure. So does the entity provide translation and interpretation so that individuals with limited English proficiency can participate equally and meaningfully in the program? Does the program have a non-discrimination coordinator, have grievance procedures so that aggrieved individuals and persons can, lodge complaints where the program falls down, and then disclose whether there are pending civil rights lawsuits and or administrative complaints in process. And at the end of that, the applicant must submit certification to EPA, and the certification includes the language that's on the current slide. And the applicant must have the signature of an authorized official, the title of the official, and the date that the form was signed. Next slide, please. So back in 2020, the EPA Office of Inspector General evaluated EPA's civil rights program and had a few recommendations. Chief among these were that the program should provide reasonable assurance that organizations that receive EPA funding must comply with Title VI of the Civil Rights Act of 1964. So the recommendation was that EPA provide some sort of verification that the funding applicant must address potential non-compliance with a written agreement before the funds are awarded. Next slide, please. So EPA accepted this recommendation, and we have put forward a program to ensure that applicants and recipients of EPA financial assistance are compliant with Title VI of the Civil Rights Act of 1964. The revised process was developed to serve as for the goal of efficiency, given the limitations that we have on our resources. We are a relatively small office at headquarters, while also conveying to the recipients that they are expected to demonstrate compliance with civil rights laws and EPA's non-discrimination regulation. Next slide, please. So that's our 4700-4 pre-award process. That way, we are ensuring that applicants and recipients comply with the rules before they get the grant. The next step is what are we doing in order to come to ensure compliance after the applicant and recipients receive our grant money. One of the programs we have is an affirmative compliance review. This is something that's relatively new. We've only had, prior to 2021, we had only had a handful of compliance reviews that we had initiated. This is in comparison to our usual mode of operation, which is to respond to complaints from the aggrieved public through the process that Dan just explained to you. So under a compliance review, EPA or OECRC initiates an investigation of particular aspects of a recipient's programs or activities to determine whether they comply with civil rights laws and our non-discrimination regulations. We do have a process for prioritizing and selecting compliance reviews, which we have posted on our website, and I'm happy to share that if you have questions about it. Next slide, please. The other mechanism for us to ensure compliance with the civil rights requirements is through response to complaints. And so when we get a complaint from aggrieved persons, we have to go through what we call a jurisdictional determination to see if we can assert jurisdiction over the issues complained of. So we have 4 requirements under our regulations, which you can find in 40 CFR Part 7. The first requirement is that the complaint has to be in writing and it has to be signed. The idea being that there is someone taking charge of the complaint that we can discuss the complaint with and follow up if we had questions. A second requirement we have is that the complaint has to describe a discriminatory act that, if we assume for it to be true, would violate EPA's non-discrimination regulations, which include race, color, national origin, which includes limited English proficiency, disability, sex, or age. We can also open complaints for allegations of intimidation or retaliation. The third requirement is that the complaint has to identify an applicant or recipient of EPA financial assistance. That's the only way that we can remedy the situation. And the third requirement is that the act that is described in number 2 has to have occurred within 180 days of the alleged discriminatory act. Next slide, please. So in addition to the 4 jurisdictional pillars that I just described, we do have other factors that we need to consider before we can accept the complaint. And the bubbles that just flashed up on your screen describe some of the issues, and I'll just go over some of them and not all. So one of the things we look at is whether the allegations described in the complaint are grounded in fact, and are they grounded with enough detail that we can infer that a discrimination occurred. We also have to ensure that there is no other parallel proceeding that's occurring on the same allegation. Obviously, that would be an efficiency measure. And then finally, are the allegations described in the complaint ready to be investigated? And that addresses the rightness issue. Next slide, please. So at the end of that jurisdictional determination, we make one of four decisions. Do we accept the complaint? If we accept the complaint, there are steps that follow. We can reject the complaint for lack of jurisdiction and or some of the prudential issues that I just described. The third is that we could reject and refer the complaint, which is when we decide that even though we cannot accept the complaint for various reasons, there may be another federal agency that is more appropriate to investigate the allegations. In that case, we refer the complaint to the other federal agency. And some of the agencies that we make frequent referrals to, because we have some overlapping actions, is HUD, the Housing and Urban Development Department, the Department of Transportation, and sometimes the Department of Energy. In addition, if we accept the complaint, we may choose to coordinate with other federal agencies because maybe the allegations described overlap with their jurisdiction. And as Dan mentioned, DOJ has coordination of civil rights issues under Executive Order 12250. So often the coordination occurs through the aegis of DOJ. So if we do accept the complaint, we investigate the allegations in accordance with 40 CFR 7.115C1, which provides that we complete our investigation within 180 calendar days of accepting the complaint. And once that investigation is completed, we issue preliminary findings. However, we also are obligated under our regulations to pursue informal resolution of a complaint in as much as possible. So if a recipient of EPA funding involved in the complaint agrees to pursue informal resolution, we told the 180-day time period to resolve the complaint, at which point we offer the recipient several ways of reaching resolution. The first is to go through what we call alternative dispute resolution, which is essentially mediation. If the recipient chooses that mode, we would ask the complainant whether the complainant would be amenable to pursue that mode of resolution. And if they both agree, then we pay for the mediation, and the two parties negotiate an agreement. And once they've reached an agreement, they bring it to us to ensure that whatever agreement they arrive at satisfies the requirements of the civil rights program, and then we approve the agreement, and the parties implement. The second way for informal resolution to occur is for the recipient to agree to engage in informal resolution, and that would be a negotiation between OECRC and the recipient, at which point we would reach an agreement that would fulfill obligations of the recipient under our civil rights regulations and the law, and then the recipient would implement. Next slide, please. So we believe in choices, and even under the informal resolution banner, we have two ways of resolving a complaint. So the informal resolution that I just described to you is one way. The other way is a program that we just initiated maybe a couple of years ago, which is called the IRA Plus, or the facilitated IRA process. Next slide, please. So under the IRA Plus facilitated process, we have joint meetings between the complainant and the recipient, where they are both able to discuss their concerns and challenges. We continue fact-finding about the allegations. And when the parties have their meetings, we take note as part of that fact-finding process. And we use the issues discussed by the parties to craft an agreement that both addresses the concerns of the complainants and ensures compliance with our civil rights requirements. However, that agreement is between OECRC and the recipient, and not a three-party agreement. Next slide, please. Informal ADR is, again, a process where the recipient and complainant undergo mediation, and they arrive at an agreement that we would check to ensure compliance with civil rights requirements. And then we would have the two parties, recipient implementing the program that they agreed to, and the complainant monitor their compliance with the agreement. And if the recipient does not fully implement the program that was agreed to in the ADR, then the complainant can come back to EPA, and we would look into whether any allegations of non-compliance with the agreement is true. And if we suspect that there's non-compliance, we reserve the right to reopen the investigation. Next slide, please. In the IRA context, if the negotiations between OECRC and recipient do not conclude in an IRA or an informal resolution agreement, then our investigation towards issuing preliminary findings resumes, and we pick up where we left off as of the date that they agreed to pursue IRA. OECRC would give notice at this point to both the complainant and the recipient that we had resumed our investigation. Next slide, please. So what does a preliminary finding from OECRC include? So our non-discrimination, I'm sorry, something just flashed up on my screen. OECRC to notify to the recipient that preliminary findings are issued within 180 days after acceptance, and we issue any recommendations that we have for the recipient to come back into compliance with the non-discrimination rules and civil rights laws. These recommendations can be very detailed and basically would outline a program for the recipient to return to compliance. the recipient would have the option to engage in voluntary compliance negotiations with us. And our preliminary findings could include partial findings. So, it doesn't have to include every allegation that's made in the complaint. We've also often had partial findings where, we've issued findings on some parts of the complaint and continued our investigation into other parts of the complaint. Or we would enter into an IRA process with the recipient on the remaining allegations. The preliminary findings could include preliminary findings of law or preliminary findings of fact, or if we cannot find sufficient evidence to make a finding of law or fact, we so state in our preliminary finding letter. And the finding of insufficient evidence could be on one or more issues under investigation. Next slide, please. So what follows a preliminary finding? The preliminary finding is followed by various enforcement actions. So as I said, the recipient, after we issue preliminary findings, is offered an opportunity to enter into negotiations towards a voluntary compliance agreement. But if they do not agree to that process, then we will issue a notice of impending enforcement action. An enforcement action could include that we would initiate administrative proceedings to terminate or refuse to grant or continue financial assistance to the recipient, or we can use other legal means, which could include a referral to the Department of Justice for appropriate action. Next slide, please. So some of the other things that are within our investigatory authority are to ensure that the recipient has what we call procedural safeguards in their programs or activities. And I'll go over some of the best practices and some of the requirements that we have. So there are some procedural requirements under the statute and our regulations that recipients must adhere to in order to maintain compliance with civil rights program. So OECRC does provide technical assistance towards achieving these procedural safeguards. And that's because EPA believes that civil rights complaints and concerns that are filed with EPA may also be addressed proactively if the recipients were to implement a robust civil rights compliance program. Next slide, please. So some of the legal requirements for applicants and recipients of EPA financial assistance includes, one, that they have to designate at least one person to coordinate efforts to comply with federal civil rights requirements. And this is what we call this non-discrimination coordinator. The second requirement is they have to provide initial and ongoing notice of non-discrimination. They also have to adopt grievance procedures that assure that they promptly and fairly resolve complaints. And finally, recipients are required to collect and maintain and provide civil rights compliance information. And this includes the collection of demographic information. Next slide, please. Additional obligations under the civil rights laws is that recipients have to take reasonable steps to provide meaningful access for persons with limited English proficiencies, what we call LEP individuals. Under Title VI, that also includes prohibition against discrimination on the basis of national origin. Recipients also have to provide persons with disabilities the opportunity to fully participate under Section 504 of the Rehabilitation Act. And this includes things like having information that is accessible to individuals with, for example, limited sight, or allowing individuals with limited speech abilities to participate in meetings. Recipients have to implement public participation policies and processes that ensure the meaningful involvement of the public. So recall that under Title VI, no person in the United States shall be on the ground of race or color or national origin be excluded from participation. So that's one of the pillars of our programs. Next slide, please. So what does the Civil Rights Coordinator do? The Civil Rights Coordinator typically is required to provide an overarching service to their to the recipient to ensure that the recipient complies with federal civil rights laws and regulations. Every recipient must designate one of these coordinators if they are of an entity that employs more than 15 employees. The regulations also has provisions for this requirement if the recipient has fewer than 15 employees, if there is reason to believe that they need a coordinator. The coordinator must also provide effective services to the recipient and must have the authority and support necessary to ensure compliance with civil rights laws. And you will find on our website a procedural safeguards checklist that describes in more detail what a civil rights coordinator duties would be. Next slide, please. And then the entity must provide a notice of discrimination. Under our regulation, this notice has to be published in a prominent place of the recipient's webpage or offices and what have you. And the notice has to say that the recipient does not discriminate on the basis of race, color, national origin, sex, or age, or disability. The notice has to be accessible to individuals with hearing or vision impairments, or if they have limited English proficiency. And the notice also has to identify the non-discrimination coordinator. Next slide, please. Oh, and the notice must also say that it is against the law to intimidate and retaliate. The recipient must also have a grievance procedure. Again, this is intended as a measure to ensure that the aggrieved public has a way of complaining to the recipient when they have experienced discrimination. Next slide, please. And then the recipient must also collect data on their programs. And EPA interprets this requirement as requiring the collection of demographic data of individuals and persons that come into contact or is affected by the recipient's programming or actions. So data collection is a cornerstone of civil rights compliance, and federal agencies have a mandate to collect the data necessary to ensure that federal financial assistance recipients comply with the law. Data collection is also necessary to inform the recipient's compliance activities. And it ensures that EPA has sufficient information to ensure that its civil rights programs and requirements are complied with. Next slide, please. So a best practice under data collection would be review and update the data that are collected at least annually, if not more frequently. Use the date to inform the agency decisions, use the data to inform agency decisions and actions, and then make the data available publicly, preferably on a public facing, easy to access platform like the agency's website. Next slide, please. I will just leave you with that meaningful access for individuals and persons with limited English proficiency includes things like allowing individuals who do not speak English as their primary language and who have limited ability to speak, read, write, or understand English, the ability to participate. And we've interpreted this as providing translation, providing interpretation at public meetings, and providing support for individuals who do not have the ability to speak or write English. And I will leave you with that.